Friends, we are going to start now. Today is 174th Friday group meeting. The topic is recent judgments, Supreme Court judgments, landmark Supreme Court judgments of in criminal law in the year 2022. Our speaker is beloved Senior Advocate, former Justice, Chief Justice of Jharkhand. So he is going to address us. I request Geetanjali Sharma and Saket Gautam and Anita Yadav, Priyanka, please come to sir. Okay then. Now sir completed just now 50 years. Mr. Uday Lalit went to Chennai. We'll give a small felicitation on behalf of Friday group. Please come, closely come. You go, please. Yadav come, please come. Yeah. Anita, please come. Anita, please. Usko there. Anita, please.
There and the afterwards are very good.
Photo le lo, sab photo le lo. Just 50 years, I mean. Uday Lalit went all the way from Delhi and he attended at Chennai. It's a huge function. I am unable to go because that's a Rama Subramanian's lecture on that day. I could not attend. I mean, thank you very much, sir. Yadav, apne paas rakh lo, sarkar. Now we'll start. I mean, please. I mean, some judgments I already circulated. You go through that. If necessary, PDF we will. I mean.
Congratulations, sir.
It's okay. Wire लगेगा देखो, उसको टाइट करो. ये वायर पीछे करो. ये वायर
ठीक है सर, ठीक है.
नहीं नीचे आने दो. Yeah, please, sir.
My humble pranams to the lotus feet of Bhagavan. My humble namaskar to all of these members of this August audience. Today, 174th meeting. It's amazing to see that started in July 2015. Now we are in 2023 March. How it happens and all is a grace. It's amazing. 174th meeting every Friday. Especially the Friday CDs are very helpful in COVID period. Now because of the instrument of God, we have grown into 174th meeting. This will go to up to 500 meeting and 1000 meeting, and that must be arranged by the G.Seshagiri now. So I really amazed to see, not necessary to praise him, his performance. There are two kinds of intelligence: verbal intelligence, performance intelligence. Verbal intelligence is easy. Talk something more or talking whatever you think and all. But performance intelligence, G.Seshagiri Rao is embodiment of performance intelligence. That is the reason we have come. Because we all pray God to give long life to him, peaceful life and prosperity, people of Sr.Adv.Topic. So that he is a selfless person, embodiment of selflessness. That is the reason that this meeting and all. I was also very particular that our knowledge must be shared with youngsters. You know, there is a beautiful mind. The mind stored with the knowledge. If it is not shared with others, the mind stored with the knowledge, if it is not shared with others, it's a storehouse. If a mind is stored with the knowledge, shared with others, especially youngsters, your mind is the lighthouse. So I want the youngsters to learn something and all. When we are gathering here and all, we are also prepare the matter and all, like the examination. As a judge and all, preparing the matters and rendering judgment is one thing. But thing is, talking to the youngsters, talking to the judges is one thing. We talk to the judges, your lordship knows everything, which is not correct. But thing is, knowledge like we say, my lord, and all these things, and all is formal. Judges expected to know all these things. But the point is, I choose the subject why? Recent judgment of Supreme Court in 2022 on criminal law. I would have selected civil law also. But criminal law, you cannot presume the result. You cannot just expect this result only. 1 plus 1 is equal to 2. But in criminal law, 1 plus 1 is equal to 0. That is the reason. When 0 comes, when 1 comes and all, we don't know. That's the reason. Interesting. Before referring to the judgments, I want to say one incident in my personal experience. I was a lawyer in Madras High Court. I was appointed as assistant prosecutor. For about 7 years I was working, and I came out of the office, probably to do private practice. First case, I was interested with the burning case. Husband poured a kerosene over the wife and body was burnt, 90% of injuries. That case interested to me. That accused person has been convicted for 10 years by the trial court. Matter comes to High Court. High Court, I was the only person who has resigned the post and I came out, and we come to know all the judges. So in order to hand over the matter to a person, I was asked to take up the matter. I went through the matter. I went through completely. I told the client, Mr. 10 years, you have poured kerosene over your wife, 90% of burn injuries. I cannot get an acquittal. Any advocate says, I can get an acquittal, I cannot get an acquittal. But I said, I cannot get an acquittal, but I may argue the matter for a question of sentence. I will request the judge to reduce the sentence of 10 years into 5 years or fine and all. Then he said, he is the son of a Tamil Pandit. He said, whatever you say, sir, I will do it. What is the property, area of the property you have got? 50 acres. Can you settle 25 acres in favor of wife? I expected he will not able to. But he says, yes, sir, I will do it, sir. Then also quoted a couplet. Inna Seidarai Urutal, Avarnanan Annayam Seidvidal. In Tamil. That means, even to a person who has caused harm, do good thing him to make feel shy that he has committed a mistake. Sir, I want to give a 25% to my wife. No problem. Matter came before Justice came Natarajan. I begin the arguments. 10 years, burning case. I just requested the court, my lord, at the outset I can say I am not going for argument or acquittal. This is not a case for acquittal. Because the point is, I come from prosecutor's office, then naturally prosecutor's mind will be there. So I thought I could see for reduction of sentence. Judge said, yes, I want something time, my lord, because I want to settle the matter. Yes. Then next week he came, husband came, sir, this is a document by which I have settled the property in favor of my wife. This is my wife, sir. Wife also has come. Wife also has come. Wife says, sir, you argue for an acquittal, sir. I just now joined him. Madam, I can argue for question of sentence because now the property has been settled, you also joined. But conviction cannot be set aside. Then I said, then I argued the matter. Next week came, before Justice came Natarajan, I opened the matter, as I promised, my lord, I would not argue for the acquittal. Judge will be happy because easy disposal. But he says, yes, I just open. Mr. Karpaga Vinayagam, you argue the matter entirety. Then I argued the matter because first pouring kerosene and left and she was taken to hospital. Hospital, initially father-in-law and mother-in-law saved her. At instance, initially she said it is a stove burst. Then subsequently magistrate comes, recording a statement, husband only poured. Then doctor, husband only poured. Then he was went to the 164 statement, husband only pours. So all these things are there. So immediately I said, my lord, this is the reason, these are the materials. So I could insist for a questioner sentence. Because these are the witness has been examined as a period 1, the victim has been examined in period 1. We cannot disbelieve her. So your lordship may consider. Then prosecutor stood up and argued the matter of conviction. Then post for judgment. It is reserved for judgment on Friday. Posted Monday. Night they will, both of them came to my office and asked, the wife asked, sir, anyhow you get an acquittal, sir. Madam, I finished my argument. Where is the question of acquittal? Then he come on Monday. Then Monday matter was first matter, post for judgment. Justice K. Natarajan called the girl and husband. Mr. Hereafter, don't harm her, don't cause any hurt to her. Be careful, treat her well. This advice. Yes, my lord. Then he just reads the judgment. Justice K. Natarajan reads judgment saying, Madam and husband, I am not acceptable for the arguments of Mr. Karpaga Vinayagam. He wants to reduce the sentence, but I won't. But I am acquitting you. I am giving an acquittal because your husband, your lawyer argued very well, and you argued also fair conduct and all. I got the materials to acquitted. I felt that I myself got acquitted. That's a criminal case. I am saying that criminal case, unexpected things and all happens. Where we say conviction will confirm, acquittal. Where we say conviction will be acquittal, confirm. It's like SLP. Arguing the matter, seeing the notice will be ordered. Where we expect notice will be ordered, no notice. Where we expect notice will be ordered, it is dismissed. So such things and all happens. He acquitted. I thought, you see the small minded, I thought only because of my fair conduct, judge is convinced for helping me to acquit. That's what I thought. See I thought it's not correct, it's not appropriate. I felt, naturally I felt just that thought only because of my effort, only because of fair conduct made the judge to convince himself and to help me. That's what I thought. Acquittal. Evening both of them came to my office with a big garland, then bigger than this bouquet, and gave the garland and gave the fruits and all, gave the cover also. Cover contains notes. Already I got the fees and all. No, this is a compliment to you. I hand it over to you. I felt very happy because where the conviction has to be confirmed, I got an acquittal. I feel proud. I felt proud. Then, madam, Mr. So-and-so, you can leave now. You can give the cover, you can take it cover back. You can use it. But don't just ill-treat your wife. Very important. Wife has joined you. Very advised him. I was very happy. Within half an hour, she alone came. Where is your husband? No, sir, I want to tell the truth. What is the truth? My husband did not pour the kerosene on me. He told me. I was taken aback. How it has happened, sir? My father sent a Sirvarisai articles for Pongal function, Sirvarisai articles through a Harijan family. Harijan means Dalit. We belong to higher community, but when the Harijan comes with the Sirvarisai article, my husband got angry and he abused my father like anything. I did not bear that. Then he abused me, abused the Harijans, abused other people and went out. I got angry. I wanted to commit suicide. I took the kerosene bottle, went to the washroom and poured the kerosene and set fire to it. On hearing the cry, my father-in-law and mother-in-law came running into the bathroom and saved her. I was having a 80%, 90% burn injuries. We were taken to the hospital. I was asked by the father-in-law to tell because of the stove burst. Accordingly, I said, my father and mother came and asked you, you have got 80% of burn injuries. Your husband will not take you back. So tell the magistrate or tell the police that only because of husband's pouring kerosene, you got fired. Accordingly, she gave a statement. To the magistrate, gave a statement to the doctor and gave a statement, deposition in the court also. Ultimately, conviction 10 years. You know, the message I got it, I was very, that's a message I am going to give this meeting and all. Where we think there's a case of conviction, but acquittal, even without expectation, even without arguing the matter, I have not argued for the acquittal, that immediately judge said acquittal. I was under the impression, it's ego. I was under the impression only because of me, only because of my fair conduct, he acquitted. That's not correct. What does it mean? Truth triumphs. Truth triumphs. That is the reason that truth goes into the judge mind and see a man is acquitted. So that is a criminal case and all. We cannot expect anything and all. That's the reason in a criminal case is quite interesting in the sense and all. Every man comes to the box, he gets afraid. Judge also will make him fear. And the cross-examination lawyers also will sufficiently threaten him. It's a punishment for the witnesses. So that is a case where my feeling is the truth alone triumphs. And whatever it is, if you got the negative order and all, don't worry at all. What is next? What is next? What is next and all? You must give utmost respect to the judges. Some judges may be kind to you, some judges may be harsh. But thing is, don't react that. The judges and all, they are sitting from 10 o'clock, 10:30 to 4:30, getting boredom. That is the reason some judges come to the library to have a change and all. But whatever it is, truth will triumph. Whatever it is, your karmanyevadhikarasya mahaphaleshu kadachana. You say your work, you do your work, but result in your hands, result in the God. And result comes. So be happy with your job. Happy with your job. Work hard, regardless of the reward. Work hard, regardless of the reward. Idea is, work itself is the reward. When you get a job, what is job? What is spelling of job? J-O-B. Expansion is joyful obligation.
Very good, sir. Very good.
See, my compliments is more powerful than the bouquet. What's the name, madam?
Sir, Himlata Sharma lies in Master my advocate.
So, very small name. I thought small name is a very That's right. The point is, always be smiling in the court. Be judges watching you, whether you're enjoying or don't show your other things and all the feeling. Be happy, be smiley, and in fact you enjoy the questions. Judges may ask some questions, may be irrelevant for you, but he is relevant for some other purpose. Like that all, the judges also, advocates also, exactly this is a question, my lord, I put to my client. Usual. When a difficult question is asked, my lord, this is the exact question I put to my client, is false. But judges will be happy. So our intelligence is being endorsed and all judges will be happy. That is the reason that is a handling the issue in court. It's an art, sir. It's like a cross-examination. Witness cross-examination giving a good answer like that. Whatever the questions asked by the judge and all, you must be able to give correct answer. If you are not able to give the correct answer, you know what I should say. Your lordship knows everything. That would be the better answer. But point is, be thorough. Even when I was arguing as a defense counsel and all, I used to read papers 10 times with my dictation, notes and all the notes and all. I just give it to my juniors, and after dictation, I will be fully equipped. I will be having completely, even the names, witnesses, period 3, period 31, names also will be always remembered. Even after 20 years, even some cases we conducted in this High Court, I still remember that. This is a thorough preparation. Now we will come to Supreme Court judgments. Why I selected these judgments and all? There are so many judgments, more than 100 judgments are there, but I selected only 6 because it's quite a very interesting facts and interesting results. First case is Mohammed Feroz versus State of Madhya Pradesh. Correct? Correct. This is the first judgment. The judgment is 2022, volume 7, 443. Mohammed Feroz, State of Madhya Pradesh. The person called Mohammed Feroz. On 17/4/2013, Mohammed Feroz and one other friend and all is a Rakesh Chaudhary. Both of them come to the house of the victim's house. In this case, victim is 4 years old, Pooja. And he came along with the, Chaudhary came along with the Mohammed Feroz to the house of victim's mother, asking her, sir, my friend Feroz has come. He wants to a shelter for today only. Let them stay here for one day. Mother refused. Mother's mother also refused. Then Chaudhary has left, leaving that man, Feroz, in the house itself. He was sitting in the house. He was sitting outside the house. Feroz sitting outside the house. Then mother came after half an hour, came outside, and Pooja was playing with other friends and all. He was sitting. Thereafter, after half an hour later, she came back and come outside and see both Pooja is missing and this fellow is missing. Feroz also missing. She was searching for them. Immediately within half an hour, one brother's son comes with bananas. Where is the child? No, we have brought the child to get bananas. At the time, Feroz was standing there. Feroz got full bananas and asked them to take bananas. I have taken. Now she has taken. He has taken that the lady Pooja, 4 years old, to his house. Then they got. Then they gave a complaint to the police. Next day, 18th, occurrence took place 17/4/2013. 18/4 morning, somebody comes and says there is a body is just left in the near the pond. All of them got struck, all surprised and shocked and go there. And Pooja was laid down. Not a dead body, unconscious. Immediately she was taken to the hospital, local hospital, serious condition. Then next to Taluk hospital, then district hospital. that was taken on 18/4. What happened and all? Who is the responsible for that? Feroz, not available. In the meantime, Feroz from that place and all, he has gone to Bihar, hometown. So that he is the person concerned, is a culprit. They naturally gave a statement to the police. Police recorded a statement from all the witnesses. Lost seen two other witnesses, all statement recorded. The accused Feroz was arrested on 23/4/2013. Then he gave a statement stating, yes, I have only I wanted to rape her and this happened. On 29/4, in spite of treatment, good treatment, she died. 17/4, 29/4, she died. Thereafter, the accused was charged for the offences 302, 376, all these things, including the POCSO Act, 8 of POCSO Act. So 4 years old. Charge sheet filed. Trial court convicted. Death sentence. You will be happy because such a level she was raped and injuries on nostrils, injuries on mouth, injuries on genitals, everything, various lot of injuries on the body. Death sentence by trial court. Death sentence by the High Court. It has come to Supreme Court. Supreme Court, the appeal filed has been Feroz, Mohammed Feroz, SLP. SLP also lot of the evidence about injuries, evidence about the accused confession statement, evidence about that identification parade, in the parade, and identification in the court, full of materials relating to concerning by conviction. But Supreme Court, see the ultimate end, set aside the death sentence. Why? Converted into life. Why converted into life? The reason is, doctors all the says, she was smothered, the accused smothered nose and nostrils, mouth. While doing the intercourse, he smothered in order to prevent her crying sound. Smothered, and when he is smothered, not able to breathe, so he died. So Supreme Court comes to the conclusion, when he smothered the nose and mouth, he did not have the intention to cause death. He was not having the knowledge. 302, 304, there is a difference. 302, intention to murder, cause death. 304 is lesser, culpable homicide, intention to cause such injury as is likely to cause death. Or knowledge to cause injury as is likely to cause death. It's not 302. It's not a murder. Not all the murders are murders. If you look into it, if a legal brain goes into it, you can make even murder as a culpable homicide. Then Supreme Court says, when the smothering was done, because concentration only in intercourse, smothering was done, he may not have the intention to cause injury on the mouth. He may not have the knowledge that she will die. That is the reason it was converted into 304 part 1 or 2, and it was life sentence. And life, not only life sentence is converted into 20 years period, unremittable term, 20 years period. Not a life means entire life, but say life means life sentence for him with 20 years of unremittable term. These cases and all, this 2022, this has been given by the 3 judges bench, especially Justice Lalita, heading the bench and all. He gave us judgment. How clear on a normal eye and all, see the murder, it will be murder. But Supreme Court says, yes, at that time, what is the mental things and all? What happened to him? What is the content? What is the intent of him? When he does an act, what is the intent? It's a very, of course, very unfortunate case. But thing is, legal interpretation. When I come to Supreme Court, legal interpretation says, that give a life and make a life, not only life, 20 years only. So it will give a reformation to him. He will think, even sometimes death sentence is a lesser sentence, but life sentence is very dangerous. 20 years jail and all without remission is a very aggressive. So that is a important thing and all. I wanted to quote this judgment because of where death sentence has been given, trial court, on the basis of the various materials. Where death sentence has been confirmed by the High Court, Supreme Court find out a point saying that it's not a murder. Merely because prejudice will be there. POCSO Act, child 4 years, the way in which he conducted. But thing is, legally we must inspect. Legally we have to consider that. This is the first judgment. Second judgment is Attorney General versus Sadish. Attorney General versus Sadish. 2022 5 SCC 545. There is also, the lady was POCSO Act, lady 12 years old. On a particular date or all, she goes to the market to get the fruits. Then the Sadish, a person who is locally residing, nearby residing, he convinced her, please come to my house. There are a lot of kwas, there are a lot of apples are there, I will give it. The naturally 12 years girl, he goes, first floor goes there, and first floor he was just showing all gymnastics and all. Then he was about to remove the salwar. Then she was wearing a jacket. He began to press the breast. She was crying. And immediately, crying, he comes out and locks the door from outside. Then coming to the ground floor, first floor, ground floor. At that time, mother searching for the daughter. And this man says, sir, your daughter has gone to the house of so-and-so, Sadish house. Then went to Sadish house, Sadish comes down. Asked Sadish, where is my daughter? No, she has not come. Utter lie. Then she went to the first floor, she got a cry sound. Then opened the door, because locked from outside. Opened the door and that she was crying like anything, shivering. He said, I was just taken by him and pressing the breast, and it was not, then removing the salwar, I was about to cry. When crying sound is more and all, he went out and locked outside. This is also, I think, this POCSO Act, other things and all. POCSO Act and all, 3 years, 5 years, all these things and all. The first POCSO Act and other 354, outraging modesty, 354, 342, 354. Conviction was given by trial court for all the offences. POCSO Act, 354, 342. Injuries were there. All these things are there. Trial court convicted for this. High Court acquitted in respect of POCSO Act. You know the reason, peculiar reason. Allegation is pressing the breast. Breast was covered by a jacket. Top was not removed. He only pressed the breast outside the breast. So it is not a POCSO Act. That's what High Court said. So skin to skin only POCSO Act. Not your body, you are not touching the skin. You are not removing the top. You are not going inside. You are not entering your hand inside the jacket. But on the other hand, you press the breast outside. That's a very, very peculiar judgment by High Court. But Supreme Court has given elaborate judgment and all. This is something very, very important in that area. In that period and all, it was it's called Attorney General for India. Here is a case where SLP has been filed not only by the state, Attorney General himself filed it, and Public Prosecutor filed it, State filed it, everything filed it. And Sadish, because the Sadish accused, argument was what? I have not done anything. I was about to remove the salwar, that's all. I was not just causing any injury, just argument. But Supreme Court rejected the argument. Supreme Court elaborately detailed about what is the sexual assault, what is the meant by sexual harassment, what is meant by sexual intent. There is a section where you touches the vagina, other people and all is all right. But when you do some act with the sexual intent, Fox Act will come. You do some act with the sexual intent, then you come. Supreme Court just converted into original restoration of the trial court and appellate court order, that is to say, saying need not be skin to skin. Maybe one skin has been used, hand has been used, or you wanted to remove the salwar for what purpose? So he was convicted 5 years. This is a very famous judgment. Attorney General versus Satish, 2022, 5 SAC 545. Next decision is a very unfortunate decision is Rahul versus NCT of Delhi. This is a case where 3 accused kidnapped a girl by name Anamika, raped her, killed her, throwing the body into a pond. This is a case and all. Death sentence has been given by the trial court correctly. This death sentence has been confirmed by the High Court correctly. But Supreme Court acquitted. How? A telephone comes to the police station. Sir, one lady has been kidnapped in a Tata Indica car by the accused persons. Then police came and the friends of Anamika were there on Saraswati, Piruli 29. Got a statement from her stating that Tata Anamika car came and some people came there and took her away forcibly and took her away. After some time, 2 or 3 days and all, Indigo car was driven by this Rahul. But point is and all, when Anamika was taken, police came, recorded a statement, investigation started. Within 2 days, 3 days, that Rahul was arrested with the Anamika car. Indica car, Tata Indica car. Arrested. And on his confession, other people also have been arrested. On their confession, the spot at the body was kept so. It's a clear case. Body was kept and body was removed. She was dead, and injury all over body and face injuries, vaginal injuries, all these things are there. Doctor says raped and killed. And the accused also has given a confession stating that they have raped or killed. This is a clear case. But High Court, death sentence was given by trial court. Death sentence was given by the High Court. But Supreme Court acquittal. What is the reason? Reason is they have recorded the confession of the accused, which is not admissible. Hit under Section 25 of the Evidence Act. Number 1. Number 2. They have recovered a mobile belonging to the deceased, Anamika. But the mobile has been filed, but not a 65 Evidence Act certificate. With reference to recall records and all, they must get a certificate under 65 Evidence Act, not. No identification period. Even the witnesses did not identify even the car. The witnesses did not identify even the accused persons in the court. In what way they could be convicted? And the minimal knowledge about criminal law and all, police officers should not have marked a confession statement of the accused. Accused gives a complete confession stating, we only did it, we raped, both are raped, it is a gang rape and we throw the body, freeze the body. In spite of it, you cannot. Just going through the spot and all taking one thing, but you cannot take into consideration admissibility of the confession given. So on these things and all, even when we go to the trial court judgment, we feel yes, correct judgment. High court, we feel correct judgment. Supreme Court says no. How can we convict? So Supreme Court ultimately judicial mind has been applied. He may be a bad man, but judicial mind has been applied, and because legality should not die. Man can die, but legal provisions should not die. That's a concept. Then this is a third judgment. Then fourth judgment is Sadendra Kumar until CBI 2022-10 SAC 51. This is a recent judgment. Everybody should read it. How a bail to be considered, how anticipated bail to be considered, what is the direction could be given. A direction has been given by the division bench. Just Sundaresh has given a judgment, very elaborate judgment. It contains about 25 pages. Everybody, youngsters must read that. This judgment, Sadendra until 2022-10 SAC 51. If you want it, you can collect the copy from here. Whoever wants and all, you can collect the copy here. And this is a judgment where they say bail application to be disposed of within 2 weeks. Anticipated bail application to be disposed of within 4 weeks. Such a direction has been given. One more interesting thing has been given is, for example, default bail is there. If a charge sheet is not filed within 90 days or 180 days, bail ought to be granted. It's called a default bail. But in one case, charge sheet has been filed. So, after expiry of time, application has been filed. Of course, charge sheet has been filed, but it has not been taken cognizance by the court. Because usually charge sheet has been filed before the magistrate. Magistrate will take cognizance of the particular offences and then commit it to sessions. But the argument has been advanced. Charge sheet has been filed, maybe in time, but it has not been taken cognizance by the magistrate. So therefore, it is not a charge sheet amounted to default bail or to be considered. This judgment. Now Supreme Court has in this decision says, where charge sheet is filed, it need not be charge sheet taken cognizance. Once charge sheet is filed, it is amount to saying that default bail cannot be considered. This is a very important judgment. This is fourth judgment. Then fifth judgment, Mafatlal vs. State of Rajasthan, 2022, Volume 6, SCC 589. These are all very, very interesting facts. A lady of 17 years has been kidnapped by an adult. 2005, missing case complaint given, not able to trace the whereabouts of accused or the girl. So ultimately, in 2010, the police officer filed a report requesting to initiate inquiry under Section 299. That is not abscond, not available, they are absconding, not able to finish the investigation. This is 2005, 2010. Then 2000, the FIR is pending. The inquiry report also is filed. No orders have been passed. In 2020, an application has been filed under 482 by the adult as well as by the girl who has been kidnapped. FIR. Reason is, we went up, we came out, we got married. A child is there, 8 years old. How can there be a case? So quash. This is a request before the High Court. High Court dismissed it, saying that, you know that the criteria for quashing, if allegation is there, constituting offence, no quashing. If allegation does not constitute any offence, then quashing. This is a judgment of 1960 Supreme Court 866, Kapoor vs. State of Punjab, first case. Then ultimately Bhajan Lal case, just Rosalind Pandey case. All these things and all. You can invoke 482 you can invoke 477 to quash the cases only where allegations do not constitute any offence. But here Supreme Court contends the matter. Where is the question of now the marriage is over, 15 years gone, child is there, and if time permits and all, the 8 years boy will become a lawyer and contest the matter, defending their father and mother. So this is a practical things, not only law, you apply your mind in a practical way. This is a judgment, this is a fifth judgment. Then sixth Ram Pratap as a State of Haryana 2023 Volume 3 SCC 345. 2023
Volume 2 SCC.
2 SCC 345. Ram Pratap, State of Haryana. It's an interesting case where accused has been convicted 302 120B IPC. High Court acquitted in respect of 120B, confirmed the conviction 302. What the facts are, only one Om Prakash was the deceased. Ram Pratap is accused. On a particular day, Ram Pratap came to the house of Om Prakash, took coffee and then went out, both of them went out, and about 11:30 p.m. the Om Prakash, Ram Pratap accused, come to a jeep along with the dead body of the Om Prakash. Tell his son, T.W.4, saying that this is something, he died in my house, please, this is the body. Then T.W.4 give a complaint to the police. I have got a suspicion over the Ram Pratap, so please register a case against him. Only on suspicion, case registered. Then when the evidence was there, T.W.4 says, the Ram Pratap came to me along with the Om Prakash and told me that he only committed the murder. So improvement. First case, suspicion. Second case, during the course of exposition, he only killed the person. So it's an extrajudicial confession, is one thing, very weak piece of evidence. Another thing is completely improvement. In first case, first stage, you say suspicion. Suspicion may not take place as proof. Any amount of grave suspicion may not take place as proof. But here, to make the matters worse, we have given a statement to the court in deposition that he only told me that he committed the murder. So where is the question of suspicion? So on that ground, he has been acquitted correctly. This is also by the Supreme Court only. These are the 6 judgments. But apart from that, I am only pointing out that be practical. When you are a lawyer, when you are a judge and all, be practical. That also said, our decision also should be in consonance with our heritage, our culture, heritage and all. The now point is, we must feel proud that we are Indian first. We are Delhiites, but we must feel proud that we are Indians. Now Indians and all, how Indians? What a beautiful India, Punjab for fighting, Bengal for writing. Oh, what a beautiful India. This is a poem. Bengal for writing, Punjab for fighting, Bengal for writing. What a beautiful India. Kashmir for beauty, Andhra for duty. Oh, what a beautiful India. Assam for agitation, Madhya Pradesh for agitation. Oh, what a beautiful India. Orissa for temples, Jharkhand for minerals. Oh, what a beautiful India. Kerala for brains. Kerala people will be happy. Kerala for brains, Tamil Nadu for grains. Oh, what a beautiful India. So that is how we must feel. First thing, language is important. More important is we are Indians. I love my people, I love myself, but more than myself, I love my wife. I love my wife more than my wife, I love my family. I love my family more than my family, I love my community. I love my community more than my community, I love my country. I love my country more than my country, I love whole humanity. Varshudeva Kutubhava. So, let us all love each other. Sagana Bhavatu, Sagana Bonaktu, Sagaviryam, Karava Vagai, Tejasvi Navadida Mastu Mavit Rushavahai. Om Shanti. Telugu saying, Manishi Vijayaniki Aidu Metlu Avasaramu. Telugu people will be happy. Manishi Vijayaniki Aidu Metlu Avasaramu. Manchi Alochana, Manchi Pravartana, Manchi Pani, Manchi Bhavana, Manchi Matalu, Vaidum Avasaramu. Please help ever, love ever. Help all, love all. Thank you, Sairam.
Thank you very much, sir. So nice of you. Let us give a standing ovation. He is 75 and 50 years completed. For our Friday Group channel, he has given 80,000 viewers. More than 13 times he addressed our Friday Group. Thank you very much, sir. So enlightening. Yeah, how many people are really enjoyed this judgment? Can you raise your hands? Cover this, cover. Yeah, all of them, sir. Any questions you can quickly ask. Otherwise, you can join in the canteen. You can ask there also, please.
Good audience.
Yeah, very good.
Very good audience.
This is 174th Friday group meeting. It's a when? Yes, 174. Let us see 175. It may be a big. I'm trying to get a judge, something like. Let us see. We hope.